All right, wingspan. Let's go. There we go. We're on. I already did it. Too slow. Sugar up, man. Okay. Ready? David, we're recording.
Yeah, yep.
We're good? All right.
You are.
Excellent.
You are.
Okay, good evening, everyone. Welcome to the Hillsborough Township Planning Board meeting of December 4th, 2025. Please join me in a salute to the flag. Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Please be advised this meeting has been duly advertised according to Section 5 of the Open Public Meetings Act, Chapter 231, Public Law 1975, otherwise known as Sunshine Law. Notice of the 2025 annual meeting schedule has been provided to the officially designated newspapers, Township Clerk, posted on the Township's website, available here at the Hillsborough Township Municipal Complex. In addition, application documents have been made available on the Township Civic Clerk website at least 10 days prior to this evening's meeting. Complete application files are available in the Planning and Zoning Department for inspection in accordance with the public meeting notice. And with that, may I have a roll call of board members and also board and township professionals, please?
Mr. Flagg, Mr. Deb, and Mr. Smith are absent. Mr. Wagner?
Here.
Mr. Radowitz?
Here.
Mr. Vitale?
Here.
Ms. Smith?
Here.
Committeeman Lapani?
Present.
Mayor Ciccarelli?
Here.
Vice Chair Peason?
Present.
Chair Sirachi?
Here.
Mr. Force?
Present.
Mr. Bernstein?
Here.
Mr. Mayhew?
Here.
Mr. Bada?
Here.
And myself and the videographer are here.
Also, Christopher Bada, on behalf of the carrier, is here this evening, and he's on the list, so.
Welcome. Okay. Okay, we do not have any meeting minutes for consideration nor resolutions. There's no planning board business and no consideration of ordinances, so I will move to business from the floor for matters not on this evening's agenda. So if anyone from the public would like to provide any comments to the board on any matters that are not on this evening's agenda, please come up. And state your name and address for the record, please. Right there.
Good evening. Maria Janusik, 720 East Freck Avenue, Manville, New Jersey. I'm also a Hillsborough Township property owner, Block 86, Lot 3, 2155 Camp Lane Road. You mentioned, Chairman, that there are no meeting minutes. When was the last time that there were any meeting minutes for the planning board provided?
Last meeting, right?
Last meeting?
At the last meeting?
Yeah, there were some on the last meeting. At the next meeting, there should be almost, it should almost get us up to date for this calendar year.
So, at the last meeting, you had meeting minutes from what meeting?
I don't have the exact
I don't
ones,
recall.
Mr. Chairman, I don't know if you wanted me to look it up, but
No, we had them. I mean, they're available online. You can see.
Well, because looking at the planning board information, there's quite a few minutes, I think, that are not available yet. Is there a reason why those minutes aren't available?
I believe a number of them were done at the last meeting that got us through the summer and up to September. There may be
I can answer that question exactly.
October.
July 24th, September 4th, and September 11th meetings are on the last agenda.
Thank you.
And
Yeah, so
and all of the minutes for meetings prior to that are all available?
All regular, yes. All the regular meetings from the beginning of the year all the way up to that point. Yes.
All the way up to September,
Yes.
was it?
I believe it's just the October. Yes, October and November. That'll most likely be on next week's agenda.
Okay. All right, so next week's agenda, there'll be additional minutes.
Yes, that's our goal, is to get it as up to date as possible so that we don't have to go very far into 2026 where the board is still approving 2025.
Okay, another issue is quite a few applications that come before this board don't give information as far as any kind of environmental, I don't know what the word would be. If a property has wetlands or if it's in a flood zone, it doesn't have any information on that line. Shouldn't that be provided on the application? If that's on the application as one of the questions, shouldn't that information be provided on the application?
Mr. Chairman, did you want me to answer that?
You can answer that.
Okay, through the application process, there will be, depending on the application, but there could be the LOIs, letter of interpretations, that are showing the wetlands and things like that. That information needs to be also represented on the plans. Again, depending on the application, it would generally be shown on the site plan or a page. If there's a specific application you're inquiring about, we could work with you offline and provide you that info.
I'm talking about the application itself that says the name, the number of the application, who the applicant is, who the attorney is, on that one specific page, that's the application, on that one line that asks for environmental issues. Quite a few applications do not provide the information. As you're saying, later on, there's a letter of interpretation or something on a record somewhere else, but that page does not show that information. And if that's a question that's on the application, then that information should be provided, I think.
Oh, thank you. You're referring to the actual application
Yes.
page, correct?
Yes.
Okay.
So is there a reason why that's not, I think I had asked that once before at one of the applications. I said, it was known that it had wetlands and some other issue, and yet that wasn't recorded on that page. Is there a reason why that's not provided?
It's difficult to work through hypotheticals, but what I can say is as we look through that, through the looking to see if we're going to deem an application complete or not, that's something we look at. If an applicant didn't provide that information, then it could be deemed incomplete. And when they resubmit, then that's when they would provide that information. Because you're not asking for, you're not identifying a specific application. It's very difficult for me to say which one. But generally speaking, if they don't provide that information, it could deem the application incomplete.
Okay, I think the campus application initially didn't have that information. There are a few other recent ones didn't have that information. At the next meeting, I can look those up and provide information. Thank you.
Thank you. Anyone else? Okay, seeing none. Are we looking to go to executive session first?
No.
No?
Mr. Chairman, what we're proposing is that you hear Mr. Fenimore regarding Mr. Kessler regarding Campus Associates. We then hear the public relative to Harvard Way, and then we go into executive session with Mr. Bada regarding the parameters before the board comes out to deliberate.
Okay, fair enough. So,
And I will have something to add regarding the public portion when we get to that.
okay. Okay, so we will then go to public hearing, Campus Associates. Come on up for your semi-annual visit.
Here. There we go. Hi, everybody. Good evening to everybody. Stephen M. Kessler on behalf of Fernmore Homes, here to provide my every 6-month update on where things stand over at the Campus Drive residential project. I can begin with a general overview, if that's okay, where we are and where we plan to be in the coming months, and then accept whatever questions the members of the board might have or members of the public. So at this point, happy to report that site work is complete on the property. The curbs are in. We are partially paved, at least as much as we can at this point. We are installing, at this point, our electrical conduits. Once that's finished, we'll put down a base coat of asphalt. The clubhouse has been built. That is up at this point to rough mechanicals and the roof. It's not wrapped or enclosed yet, but it's up, and if you drive by, you can see it. We will, as soon as we're able to, go vertical on the first two buildings by installing foundations. Then we'll start our ground-up construction, and we'll continue to work through the winter months to get that done. The only thing we might not be able to accomplish in the winter, depending on timing and temperatures, the asphalt is tough to do in the cold temperatures. The plant will shut down at a certain point if it hasn't already. But other than that, we can work everything else through the winter months. We've been working really well with the planning department, with the building department. I will say that the town is very well represented by its building department, very well represented. You, as David put it at one point in the past, your building department is the Harvard University of building departments, and I think that is absolutely 100% correct. So the citizens of the town are very well represented by the building department. Of course, it makes our job more difficult as a builder, and it makes things a little slower than we would like to see it, but at the end of the day, your job's to represent your residents. So we fully understand that and look forward to finishing the project. Our hope is that by the time I'm back in June, we will have buildings up. Hopefully, the first two will be completed, wrapped through rough mechanical. The second two buildings should be going up by that point, if not up completely. We move very quickly once we go into vertical construction. Things will go a lot quicker at that point. So that's my general overview and update, and open it up to whatever questions you all might have or members of the public.
Okay, thank you.
Thank you, Mr. Kessler. Question, when you said site work is done, does that include all stormwater facilities? And could you just elaborate on that a little bit?
Yes, everything below ground at this point, with the exception of the electrical conduits, is complete and operational. So what that includes in the definition of site work, that would include that as well, yes.
I know you don't have a crystal ball, but what do you anticipate start to look for tenants and advertise for tenants?
So usually, what will happen is the first two buildings will obviously be completed first. As we start getting toward completion or toward a temporary CO, we'll seek a temporary certificate of occupancy from the township once we get close enough. We'll probably start reaching out to tenants a little bit in advance of that. Usually we can kind of time that out. So at this point, I mean, I can't say for sure, but based on where we are and based on how our projects generally tend to move, I would say probably sometime in the summer to give you a good estimate. But again, we're moving basically as quickly as the building department will allow us to move. So I can't say for sure, but if I had to take a stab in the dark, probably sometime in the summer we'll start looking for tenants.
And just to clarify, all your affordables are mixed in with all the regular
Correct.
tenants, so it'd be all general plus the affordable units at the same time.
Correct.
Okay.
And it's typical that the affordable units will be rented first. Typically, that's how it works. There's a long waiting list in most towns, most jurisdictions. So usually we lease up all the affordables first.
Okay,
Yeah.
thank you.
Yep. Any other board members? David?
Just as related to that question that was brought up, just a point of information for the board, there is a phasing plan that the developer is following and something that the building department is responsible for in terms of which buildings are allowed to be CO'd because of the percentage of market rate and the percentage of affordable units. There's a very specific phasing schedule that has to be followed. So just as a point of information for the board, and my department's responsible for making sure that happens. Just a question. Are you, as the developer, can you just remind us, as the developer, are you using the township's administrative agent, or?
Yeah,
Okay.
yeah, we will
Thank
be
you.
using, we almost always do.
Got it.
Just easier that way.
Okay, and you've
Yeah.
been in communication
We
with
have
our
been.
administrative agent?
We have been.
She'll be ready to go
Yeah.
Okay.
I think as we get a little closer, we'll ramp up our communication, but we had initial talks with them, and that's typically how we like to do it, is go through the town's administrative agent. Just a lot easier.
When you get a little bit closer, just make sure that you're copying the municipal housing liaison for the township.
Sure.
And if you need to reach out to me to find out who that's going to be in 2026, just let me know.
I'll do that.
Thank you.
Thank you.
That's it, Mr. Chairman.
Okay, thank you. Okay. Do I have to do a motion to public?
So moved.
All in favor?
Aye.
Aye. Okay, if there's anyone from the public that would like to question regarding the update on Campus Associates, please feel free to come up. And state your name and address for the record again, please.
Maria Janusik, 720 East Freck Avenue, Manville. So you mentioned that site work is complete. What is included in the site work?
So generally speaking, site work involves the clearing of the site, the grading of the site, the installation of stormwater, the installation of utilities, and then in preparation for the placement of foundations.
Did this property have wetlands?
So we're building this, first of all, if there are wetlands on a property, obviously we can't build in the wetland areas, in the delineation areas. I don't want to speak to any specific engineering aspect of the project. I can defer to the township's professionals. I can tell you that we are building the project in conformity with the approved plans.
So you wouldn't know if,
I believe there are wetlands. I mean, the site is basically on a creek, so I mean, I believe there are wetlands. Mark Mayhew is more familiar with the site from an engineering standpoint, but I'm fairly certain that there are, on the back of the site, wetlands.
and so if there are wetlands, they need to get approval from the New Jersey Department of Environmental Protection?
So we received any and all required approvals prior to construction. That would include any township approvals, state approvals, anything required by any state agency, local agencies, and any other regulatory agency with jurisdiction over the site.
But you don't know specifically, you haven't seen any of that. You wouldn't know whether they have it already or not, those permits.
The township would not allow us to move forward with the project, nor would we be able to do anything with the project in terms of financing or anything else without all permits and approvals being in place.
So then the place to check as far as permits would be the township.
So if you were, I'm sure, to do a Freedom of Information Act or Sunshine Act request to the township for copies of the files, the file would show all permits that we have in place for the project. Yes. A lot of it's also available online. I know that the township has a very nice, user-friendly online system when it comes to looking things like this up.
Thank you.
Sure.
Can you give me some information on the phasing plan?
So this is being built in a couple of phases. Again, that's all available. I believe it's 2 buildings and 2 buildings, and then within, it's 4 buildings total, the clubhouse being its own phase. That's why the clubhouse went up first. And then there will be 2 buildings that'll be put up first. Once those are underway, the second phase will be built, which will be the other 2 buildings. So it's basically being built in 2 phases. The third kind of quasi-phase being the clubhouse, which is built at this point.
So the other 2 buildings, what are they? Are those residential or?
So all of the buildings that we're building there are residential rental units. Interspersed with those are some of the affordable units for whatever affordable units have been required for this project.
So this project is strictly residential? There's no commercial?
No commercial in our site, no, not at all.
Okay. And it was mentioned that you would be using the administrative agent of the township. What is the purpose of that?
So anytime there are affordable units as part of a residential project, which many residential projects in the state of New Jersey have, and there's a COA requirement that we're fulfilling, we have to work with an administrative agent who helps to administer the affordable housing rental process, because it's a little different than just going out and, renting to you or to anybody else. You have to, there are regulations that have to be followed very strictly. Each township has an administrative agent that's responsible for the township's compliance. They also work with developers and owners of property in making sure that they're compliant as well. So we'll be utilizing the same company for that. We find that it just works out a lot easier.
So how many residential units are there total?
I don't have all the counts in front of me at this point. I apologize for that, but that's all available online in the application.
Okay, so you don't know how many are affordable and how many are regular?
Again, there's typically a,
All right. Ms. Janusik,
Sorry, what?
let me,
Is this relevant? This has already been, this is an approved project.
As a Hillsborough
Okay, Ms.
property owner, yeah, I
Ms.
wanted
Janusik,
to
just
ask.
questions relevant to the comments and the update that he
There are
provided.
there are
Okay.
96 residential units, 23 of them are affordable.
Okay, that was it. I don't know why it had to
Okay.
become a big production. All right, thank you.
thank you.
Thank you. Any other members, public? Okay. We'll see you in 6 months.
We'll see you in June. Thank you. All right, have a good night.
Happy
Have a good
holidays.
holidays.
Happy holidays to you as well.
Now,
Mr. Chairman, we are now going to enter into the other part of the evening's festivities, and that is the remand from Judge Menon on Harvard Way, JMJ4 LLC. As the board members who are eligible, and just for the purposes of the record, before Mr. Ogrodnik enters his appearance, the board members who are eligible to hear this application are Ms. Smith, Mr. Wagner, Committeeman Lapani, yourself, and Vice Chairman Peason. Anyone else who chooses to remain on the dais is not eligible to participate, will not be eligible to participate in deliberations or in the executive session that's going to come at some point in this evening. I think at this point, Mr. Ogrodnik should put his appearance as well as Mr. Afrin, and then I will discuss what Judge Menon stated in his last case management order.
okay, I'm just going to put into the record, this is Harvard Way, JMJ4 LLC, file number 21-PB-09-MSPV, and as Mr. Bernstein said, we'll call it the remand. So, Mr. Ogrodnik.
Good evening, members of the board. Mike Ogrodnik from Savo Shock Law Firm in Somerville, New Jersey, on behalf of the applicant Harvard Way JMJ4 LLC.
Good evening, Bruce Affron on behalf of the objectors, and I am here pursuant to the same remand.
Okay, thank you.
For the purpose of the record, Mr. Chairman, at the last board meeting, Mr. Ogrodnik was here introducing 3 permits that his client received from DEP. Mr. Flynn from his office was also here discussing what they believe were information that somehow addressed an issue involving Section 188 of the Township Code in regard to the issue of what I would euphemistically refer to as 18831E, what I would euphemistically refer to as spec warehousing. There was a discussion, Mr. Afrin had been retained to represent some of the neighborhood. There were ongoing discussions. The matter was continued. Ultimately, Mr. Afrin submitted a motion to intervene. Mr. Ogrodnik's client opposed. The township, I don't believe, took a position one way or the other. His Honor, let me read into the record His Honor's decision of October 17th, 2025, relative to both Mr. Afrin's intervention motion and a subsequent case management order that came with it. Whereas proposed interveners Green Hills Community and nonprofit corporation Scott Armstrong and Christine Coppin filed a motion seeking leave to intervene in the subject matter under Rule 433.1 or 433.2 of the New Jersey Rules of Court. And whereas the court considered the moving papers in opposition to the motion, having heard oral argument of counsel, now therefore it is on the 17th day of October 2025 ordered that the application of Green Hills Community, a nonprofit corporation, Scott Armstrong and Christine Coppin, to intervene in the subject matter is denied without prejudice for the reasons set forth on the record in open court on October 17th, 2025, at the conclusion of oral argument. His Honor then entertained discussion relative to the proceedings this evening and entered the following case management order. The remanded proceedings before the Township of Hillsborough Planning Board shall be conducted in accordance with the court's February 4th, 2025 remand order. It is the court's hope and expectation that such proceedings will conclude prior to December 31st, 2025, but it was not mandatory. 2, it was represented in court that the plaintiff has availed itself of the opportunity to supplement the record before the board, limited the presentation of certain NJDEP stamp letters of approval and the presentation of proposed conditions of approval to address. I'd also note that Mr. Flynn, Matthew Flynn, is here from Mr. Ogrodnik's office, and the presentation of proposed conditions of approval to address the board's concerns related to Hillsborough Township Ordinance Section 188-31E. Insofar as the plaintiff has supplemented the record, those areas of supplementation are appropriate for public comment, including comment by any attorney retained to represent said members of the public before the board renders any decision. Those aspects of the court's remand which are limited to the record previously adduced shall not trigger the right to public comment, but shall only instead involve board deliberation based upon the record previously adduced. Nothing herein shall preclude the defendant planning board from seeking the advice of its professional staff, example, engineer or planner, with regard to any area of the record the plaintiff has chosen to supplement. There was then a case management conference set down for next week and service of the order. Therefore, the limited public comment is related to all that was introduced at last meeting relative to the DEP and to Section 188-31E of the code from the public. No other aspect of the application is open for public comment. The board may, either in executive session or during deliberation, seek guidance from either Mr. Mayu, Mr. Flynn, Mr. Coyce, Mr. Botter, or myself where applicable relative before it comes out to deliberate.
Okay.
So at this point, Your Honor, it's, Mr. Chairman, it's a motion to open to the public.
Okay. Is there a motion to open to public?
So moved.
Second.
All in favor?
Aye.
Huh? Only the 5. Yeah. The rest just keep eating some chocolate. So, it's open to anyone from the public that would like to provide commentary on what was introduced or as outlined by Mr. Bernstein from the last, from our last public hearing. I think we got a few.
Mr. Chairman, if I may.
Mr. Affron, I would move the microphone closer. And you gotta turn it on too.
The light is on.
Uh,
Is that better? Oh, I'm sorry.
It's a bright green.
Mr. Chairman, I will make some comments on behalf of the objectors. In particular, I've seen the memo of Pannoni, and we think that that represents a proper statement of analysis as to the hydrology issues. And it's an interesting point that's often overlooked, and I compliment the engineer because there's a constant trend of thought in these types of hearings that if DEP enters a permit, somehow the board is bound to that. And that's not true. The municipal land use law actually creates and imposes on the board a separate duty to satisfy itself that issues related to hydrologies, wetlands, et cetera, are satisfied. Because this board has a different jurisdiction. And as the engineer points out, those are minimums that DEP looks at. It's not looking at the totality of the environmental laws of the state. And this board has a duty to satisfy itself that in this town, those rules are satisfied in a broader way. And that's precisely what the engineer has done. So we endorse that report, and we believe it represents something that should be incorporated into the findings. It is based solely on the evidence that has been in the record already as supplemented, and it's critiquing the permits from DEP and saying that doesn't rise to the level of the law that governs this board. And so we think those represent very appropriate forms of analysis that should be incorporated into your resolution. I do want to make a point about the evidence about the specifications of operation of the proposed warehouse. I'm not aware that any witness has testified to those specifications. And they can't simply be introduced by representation, with great respect to my colleague, of counsel. This is new information that could only find its way into your resolution if, number one, you approve of that information and find that it meets the ordinance, and number two, and most importantly, if someone testifies to it, so it can be cross-examined and tested. Right now, we don't have any evidence as to satisfying the specifications aspect of the ordinance. And so I would say that on behalf of the objectors, I don't think the board can accept that evidence in satisfaction of the ordinance, because there's no evidence. I mean, no disrespect to Mr. Grodnick, but that's not, his statements are not evidence. And even a written affidavit is not evidence in a planning board. Someone has to be here and testify to those facts so they can be tested. We have no idea whether they're credible, whether they're seeming to be reliable, whether the person who proffers them can defend them. And the public can't question that individual either. So I would say that that aspect is not satisfied, excuse me, by the applicant. And it would be improper, as a matter of basic procedure and due process, to incorporate that into any sort of positive finding on the board's part. There is no evidence to support the ordinance with respect to the specification question of operation, and therefore I think the board needs to make that type of finding. I think that with respect to one issue, and I haven't seen the draft resolution, of course, with respect to one issue, the court did ask the board to identify why it accepted the objector's expert over that of the board and that of the applicant. So I would say that that does have to be in some form in the final resolution. And I think what Pannoni has done is actually outlined a lot of the same issues. So I think it's important to note that in the resolution that the objector's expert has been found by Pannoni to be credible in these areas that were addressed, and these are reasons why the board accepts it. But I do think it's important to stress why you accept the objector's expert, otherwise you might not be meeting the standard of the remand. So I think that concludes what I had to say. I thank you very much.
Thank you. Come on up and state your name and address for the record. The mic's over there.
David Brook, 7 Winding Way.
Is that mic working?
I'm not sure, I know this is public comment, and I'm not sure whether I am in a position to ask a question or make a statement, but I guess I'll try it and see where we go. There were these documents that were submitted, the LOI, November 4th, 2024, freshwater wetland general permit 6, November 29th, 2024, some sort of recording of them, a modification and transition area waiver for wetlands 12/2/2024, and then the recording of the freshwater wetlands general permit. And I guess these are documents that are in the form of a permit of some kind from DEP, and I just wanted to get confirmation of that, but I guess I'll confirm it myself. My other question, I'm not sure if I'm allowed to ask, but there's no professional that I could see from the applicant that has testified to why DEP issued this permit. And I would like to ask Mr. Ogrodnik, but I'm not sure if I'm allowed to. So I can ask, right? There's no applicant, did not bring anybody from DEP to discuss the permit. Is that correct?
That's correct.
Okay. And I guess my question is, what if the information that served as the basis for the DEP permit was incorrect or inaccurate, and it's been presented to you to presumably rely upon? And I guess my question, again, is how can the planning board members or the township engineer now question it to get some clarity if there's nobody from the applicant or DEP to verify how they made that decision?
It's an outside agency approval. It's independent of the board.
Okay, but there's nobody that can question it at this point, is that correct?
There's an administrative hearing procedure that you could have participated in. On file with the board as all the DEP applications, supporting documents. And yeah, there is an appeal period, an administrative period, which is expired.
Okay. When I read through the judge's order, and I think Mr. Bernstein mentioned it, I just wanted to read one part. The applicant was given the opportunity by the judge in this matter to supplement the record with any proofs that its stormwater management plan could be made feasible and compliant with applicable regulations without a reclassification of the site soils from hydraulic soil group classification C to soil group D. Is that a correct statement? Okay. I took it from the judge's order. As far as I can tell, the applicant has chosen to only present paper documents to support this position. Is that correct? I get no answer, but I guess the answer is correct.
The answer is what we're permitted to do is submit the paper documents.
Okay.
That's what His Honor agreed to allow to be provided to the board at the request of the applicant. Correct me if I'm wrong, Mr. Ogrodnik.
That's correct. We actually did file a motion to supplement the record prior to the trial, which was denied. But after we had the trial and the court issued a ruling on remand, the court permitted the board ultimately to consider the approvals from DEP that do address the stormwater management compliance.
But the word of the order says supplement the record with any proofs. Does that mean only paper, or does that mean that you could bring a witness in? And I'm not sure who I asked that one of.
That's no longer an issue. It is what it is. The paperwork is submitted and the board will deal with it.
Okay, but
If I may make a comment really
No.
briefly about, well, it will clarify something Mr. Brooks is
No.
asking about. Why not?
You're not here to clarify, Mr. Afrin. If you want to make a public comment relative to such, and the chair allows for it, he can, but Mr. Brook is here to ask a question, and that's what we're here for, the
I'll
public
certainly
comment.
yield my moment if I
No,
could.
we're not, this isn't Congress either. We're not yielding time.
I will save it till Mr. Brooks concludes, and I'll then
If
raise it then.
the chair wishes to allow you to make further comment, it's up to the chair. Mr. Brook, you have
Okay.
anything else?
So, just one or two other, if I may. So apparently, the applicant has also chosen to not bring a professional witness to testify to the accuracy or the applicability, I think was the more important question, as to the documents that the applicant has submitted. And I'll just say yes, since I can answer for him. There's no engineer here tonight. There's no professional here tonight from the applicant to testify as to what they're trying to present. And the most important thing I think for the board to look at is that none of the permits that you have been provided with either list or mention anything that relates to soil group C or soil group D. That was the biggest contention for the application that was reviewed and you ultimately denied based upon those issues. And so I read through all of the permits. There is no mention of soil group C or soil group D. And so my thought is that without a professional to testify as to why these documents support the applicant's position that they're somehow suggesting that these DEP permits support the reclassification or a classification different than what the board's, different than the objector's engineer found, and I believe may be confirmed now by your own engineer. Nothing mentions soil group C or soil group D, which was in the court's order for the applicant to, or the, should say not applicant, but the plaintiff.
I'm objecting to that statement. You're mischaracterizing the record. That's not what it says at all, Mr. Brooks.
Well, we can argue about that, but let me just finish and then I'll let you, and we can go back and forth. There's nothing.
Sum up.
I'm there. There's nothing that was provided that discusses soil group C or D. The DEP permits never mention anything associated with that. And I think the biggest challenge that I have, and I presume maybe the board has, is that as it goes to these submittals on behalf of Harvard Way, the critical part is being able to question the veracity. And I will simply say to you that you can't cross-examine a piece of paper to determine those factors. And I think that's where everything submitted by the applicant fails. Thanks for your time. And it's always nice to see everybody again.
There you go. Yep. Any other members of the public? Okay. I'm going to let you, because I do not want to see the residents disenfranchised, so please comment away.
Thank you. I didn't mean to jump the gun.
No,
when
no,
Mr.
no.
Brooks
Go
was
right
up.
ahead.
No, I just wanted to point out, Mr. Chairman, that although DEP is not here as a witness, so to speak, Mr. Mayhew is here, and he did issue a report, which I addressed before, and it does actually address many of the deficits that Mr. Brooks was concerned about. I just wanted to reemphasize that. That's the only point I wanted to make.
Okay.
Thank you.
Thank you. Okay. Yep. Last bite at the apple. Okay.
Motion to
To
close.
close. Yep.
Well,
Motion to close to public.
Second.
All in favor? Aye.
Mr. Chairman, at this point, I would ask that the board go into executive session, consult with its counsel, and come back out and deliberate as per the instructions from Judge Menem. Therefore, I'm seeking a resolution to go into executive session pursuant to NJSA 10:4-12B7, attorney-client privilege, pending or anticipated litigation, Harvard Way, JMJ4 LLC versus the Township of Hillsborough Planning Board et al. The board will return from its executive session and will start to deliberate.
Just one more item before you deliberate, or before you go into exec. We would like to put on the record our objection to the report. We did receive it today, late today, but our objection is based upon that it's outside the scope of the remand and in that it's a net opinion.
Okay.
May I have a motion to go to executive?
Second?
Roll call, please.
Justified.
Mr. Wagner? Yes. Ms. Smith?
Yes.
Committeeman Lapani?
Yes.
Vice Chair Peason?
Yes.
Mayor Sarachi?
Yes.
We'll go over to conference room A. We'll leave the public.
There we go.
Bat signal, yeah. The bat signal's back, so.
Okay.
What, are you holding it for yourself now?
I mean, he's
No.
taking a look at.
You've taken control of the thing, two things next to you. Two things next to you. Of candy. Jesus Christ, guys. No, I don't care. Some of us may want. All right, Mr. Chairman, we need a motion to come back out of executive session.
Motion to come out of executive.
So moved.
Second.
Can I just do?
All in favor?
All in favor?
Aye.
Aye.
Let the record reflect that all members of the planning board present at the commencement of the executive session are present at the recommencement of the open session. Mr. Vitale was in the room, did not participate, and was not part of it. Also present was myself, Mr. Bada, Mr. Mayu, and Mr. Coyce. The executive session was the planning board seeking legal advice from Mr. Bada and myself, mostly Mr. Bada, relative to the obligations it has relative to Judge Menin's remand order, and for the board now to deliberate in accordance with that remand order to come to whatever decision it intends to come to.
Thank you. Okay. Board members, comments?
I guess I'll start, only because I was the one that started it last time. And I think we should, as a matter of just to keep the record clean, maybe to take a topic that I'll bring up, maybe the rest of the board members can comment on it, and then another board member, another topic, just to keep it, so we're all in this, the record is cleaner. I mean, obviously, time brings back things. Obviously, there was permits issued, as stated. In my opinion, permit was just part of the argument that was part of an outside agency. And obviously, when we were looking at this, permitting was never really part of the issue. It was really looking at the site and some concerns that we had. And the concern that sticks out to me that I obviously remember the most was the testimony of Dr. Emerson and the Whitestone report in particular, and the classification of soils, which was a big part of how the stormwater management was designed. And I do recall there was probably several nights of testimony on both sides of that issue by both engineers and Dr. Clay, the rebuttal, et cetera. But what seemed to be, in my opinion, in my recollection of the testimony and reading back through some of the notes and some things that were reminded of us by our engineer again, was the inconsistencies of the testing, the wells, the drill pits, whether they were being dug by hand in the bedrock, which seemed to be unrealistic. And as I joked back then, I've grown up in this town. I've had the pleasure of trying to dig in this town forever, and the subsoil is very hard. And the perk testing that was related to that, to classify a C and a D soil, I never felt that testimony was provided adequately, in my mind, that would justify a reclassification of the soil. The infield testing of versus a lab testing, which they relied on, to me was inconclusive. So there was, in my mind, there was significant doubt to accept that whole premise. And that's the first topic I feel that was a big part of the concern and the testimony that when I was looking at this whole thing, that I felt was never really completely answered.
I would agree, Sean, with what you said in reference to the testing part of it, lab testing versus in-field testing. To me, just knowing that area, previous history of that area and areas that it is, Lab testing to me just comes across as being a little bit on the sterile side, if I use that correctly, versus actually what's out in the field when you're there. So that was a question that I had that we had discussed as well. It just didn't, in my mind, it just didn't make sense given the area and the testing results. I just wanted to mention that.
Yeah, I guess I'll chime in on that. Besides the use of a spec warehouse, my mind always goes back to the concerns of the residents and the flooding concerns. And I still wasn't convinced that this would not increase or exacerbate the amount of flooding that would occur. And it all had to do with the classification of the soils, whether it's a C or a D. It seemed to lean towards a C in my mind. The D, it kind of boiled down to that. An alternative plan to have BMPs and based on a C soil, I didn't see. So yeah, mine is my mind goes back to the soils.
I feel the same way as the previous members have mentioned. I did not feel a great deal of confidence in the testing that was done. I believe there should have been in-field testing as well, which is a better indication of what type of soil there is. The entire, working through how the water is going to do all the runoff, they just based it all on D soils, which is, the state still says it's C soils, and that has not changed. And I think they could have looked into that more to assuage the valid concerns that the people who live downstream of them have as to the values of their property, their livelihoods, and so on, their lives, I should say. I think there was several times we had requested to have that kind of testing done, and it was not done.
So I think I concur, with regards to some of the doubts that Dr. Emerson raised with the test methodology, doing lab versus in-field. But, in addition, if we recall, there were 3 pits and 1 infiltration test. I think one of the other concerns was the 3 test pits, did I say pit test? Test pits, was concentrated in one area where it should have been spread out. In addition, with 1 infiltration test, as I always like to say, single data point doesn't make a trend. And I do recall numerous times requesting for additional test pits, infiltration testing, and the applicant, said no. So it wasn't like that wasn't an opportunity there, that we denied them that opportunity to determine, the classifications, of the soil. The other area, because as we know, with these applications, when they're doing design, is to reduce the peak, to basically spread out that additional volume. And one of the other things that we were looking for was some downstream testing, because as we know, the water from this area eventually goes into the Raritan. So what we needed and what we had requested, and again, the applicant said no to this, was an analysis. Because where the peak, not the peak, but where the volume runs down and how long it's delayed, we don't know how that's timed with the Raritan, because as we know, the Raritan will back up, but perhaps at a later time, and this could just exacerbate the flooding conditions that we have there. So, along the line, these are things that are not considered, when a DEP is doing their review for a permit. They're looking very myopically right at that site, not the broader impact. And that's our obligation, And I think that goes back to, where we came to or arrived at our conclusion.
Yeah, I think, Mr. Chairman, to that point, I mean, we know that certain sections of the Raritan River, having lived here in Hillsborough, rains end, and, we have it, going out to Dukes Parkway and that sort of stuff. The river doesn't crest when the rain stops, and a lot of times it's multiple hours. It could be 8 hours, 12 hours, 18 hours, and, given the headwaters of the Raritan, how wide that is, it takes a long time for those waters to get to their point, their peak point, and then slowly recede. So if you have a system that's built, okay, great, we're going to discharge this water 4 hours after the event, well, that's great, but if the water that it's discharging into doesn't peak until 12 hours or 14 hours after, that's kind of creating an issue of dumping more water into something that's still an issue. So I just wanted to kind of comment on your point as well.
Yeah, and I think also, we also did request even upstream, because I believe there is property upstream that also, feeds in there. And again, I believe those areas or that part were done before there were really stormwater regulations. So again, there's impacts from that. So again, again, I'm just going to reiterate, we provided the applicant numerous times, or we asked numerous times, requests, to do this analysis, and they flat out said no. So there was an opportunity.
Yeah, Chairman, the off-site use of this storm defense from upstream, from Dukes Parkway, and other areas that go into the storm basin were never really completely identified. So we really had no real definitive math as to this detention basin, which was in various states of disrepair that had been ignored for decades, and was not even functioning properly, and has just within the last month been, actually weeks, I should say, since this application ended over 3 years ago, finally been addressed to bring the detention basin back to standards from 1988. And so I'm happy that that's done for the residents. So I promised I would get that done. It took 3 years, but the DEP was very slow in issuing permits, whatever. We'll move on. Where the, and maybe Mark can explain there's 3 standards that when you look at stormwater and how you justify it's on peak runoffs, there are 3 different standards that need to be met, or one of the, I guess, 3 standards need to be met, and how the 100, 200 and storms affect flooding and peak flow, which the chairman has brought, and the volume. They really never demonstrated how they were able to do the correct math or analysis that would not affect the surrounding areas. Like I said, I was there during post-Ida with the governor, standing at the base of Dukes Parkway East, and it was 2 days after the storm was over and the road was still flooded. So to say that this area is not impacted severely by the 100, even a hard rainstorm now, you don't even need the big storms. The 20-year storm, we'll call it, if you want to call that a minor storm, is affected severely by this side of town, due to a lot of reasons that are out above our control. The Raritan River is higher than it used to be because of the median water level is now 10 feet higher than it was 15 years ago, so it doesn't take long to flood. All the development that's been built upstream dumps into the Raritan River, which also they are downstream from that. So the regional aspects of this area is unfortunately affected by the peak runoff and flow, which the applicant that was here before the meeting is one of the people who are putting into this basin now. That was part of an affordable housing project that we approved because we had to, but That is also adding into this same 42-inch pipe, this development that is being done right now. So I don't think that it was really brought, in my opinion, based on the testimony, that they really considered that release, if it affected the area or prevented the area from being adversely affected.
So I think the other area, and I think Mr. Peason was touching upon this, is with regards to I don't know what, I just have noted the Hillsborough section about spec applications. It's 1E8-31. I know at the time there was nothing provided as far as who were the residents, and I know His Honor allowed the applicant's attorneys to, I guess, submit proposed, I don't know what we want to call it, operations or or uses, or more importantly, I think, what it won't be. But one of the concerns I have with that was submitted by the attorney, and there was no testimony to it by the actual owner or operator, so not sure how relevant that is. And even with what was provided, it really doesn't say a lot in there. I don't know if anyone else wants to opine?
Just briefly, I'll agree. I mean, we asked numerous times about application, use, et cetera, and there was no testimony given. Even though, the application was deemed complete, doesn't mean that we have to accept it based on the planning board, because that's why we're here. So to come in and then all of a sudden have a windfall of information as to what the use might be, I don't think is really helpful in any way, because it's still speculative at best. We don't know who the applicant is, the hours, et cetera, the type of trucks. I mean, they can say what it is, but it really wasn't there. But in general, I don't think that it really matters.
Well, I don't think the attorneys are in position to speak on behalf
Right.
of the owner-operator. Plus, it doesn't even talk about content. We don't know, even if this was provided by the operator, the owner, it doesn't get into contents of what would be in the building to begin with, what type of value-added operations may be going on in there. So, even this statement as presented is still very speculative. So I don't, in my view, it doesn't meet the requirements of our ordinance.
I would agree, because if you don't actually have a prospective tenant, it really is all an unknown at this point. And as we've been saying, it's speculative, and that's not what we're looking for.
Yeah, I'm not as concerned about that. The correspondence from Mr. Flynn, stated the conditions and the maximums. That I don't necessarily have a huge concern with, though.
And I'll also just add, even though they did get a permit from the DEP, it's, as stated, it's a minimum standard. It doesn't take into effect, that's what the planning board does, the impact of the area in its entirety, how it affects the health benefit, health, safety, and welfare of the entire site. That is our charge. So just because they have a permit that says that in this little bubble, as the chairman stated, that it appears to be a plan that seems to be, I'm using legal, but wrong, compliant is a better word. That is only part of the whole application. There's plenty more of that, because quite honestly, if that's all it needed, we wouldn't need a board here. We wouldn't be the five of us who are left sitting here. It is our job to take into account all the factors of the property, its effects to the adjoining properties, both in sound, light, water, traffic, noise, which I sound, but noise. So, it's not a bubble based on a permit. So that's why, again, even the submission of these DEP permits that's an outside agency, is always subject to those, depending on the approval of the plan. Regardless, it is still subject to those as an accessory, but it is not precursive to why we can approve it or not.
Yes, Sean, I'll add to that. In Judge Menon's remand, item 3 says, "Nothing herein shall preclude the defendant planning board from seeking advice of its professional staff, example, engineer or planner, with regard to any area of the record the plaintiff has chosen to supplement." And in item 2, that supplement was in the form of a DEP permit. I'm not convinced that DEP permit took into account what our concerns were originally, in our prior decision. So, I don't know, does anybody have anything, is there something I'm missing?
No, I don't think so, Rob. I mean, it talks about, the minimum standard. Well, I don't have minimum coverage on my home and auto and that sort of stuff. I know it's a kind of a lame comparison, but, to go by the minimum standards, I think we have a right to require or request a little bit more than minimum, in my view.
Yeah. I mean, it's not a right, it's an obligation
Yeah,
that this board has.
So we have an obligation to the
Yeah.
people of this town.
sure.
All right, next.
I'm just giving some time as everyone's reviewing any of their notes. This will be our last opportunity to get something on the record. As His Honor expressed in his order that, we would be finished with this by the end of the year. And I do believe all parties are going back on December 9th.
I would just point out for the record that the board's remand is not just the remand from the last order, it's the remand from the original order. So if there is anything else relative to that remand, if the board wishes to address in terms of why it came to certain conclusions or didn't come to others, you are not just limited per se to supplementing the record.
Well, in the original, I think I kind of started my testimony with that, was the, taking into effect, I think the biggest concerns that at least I had coming into the original application was the stormwater and how it was being designed, the stormwater plan, and the testimony as to what the way to mitigate any impact to the potential residents of the area were, and the engineering that was provided by Mr. Ford, and then also the rebuttal testimony from Dr. Emerson, and even some of our own questions. There just seemed to be too many variables there that I did not feel comfortable that it was engineered that would prevent a exacerbation of storm damage downstream. I felt that the Whitestone company or the report had too many anomalies in it for me to take it completely serious. You know, I do respect their licenses. I felt it was a little sloppy at best. And then when questioned on it, there seemed to be a little pushback, and which was their right as an applicant. We asked them to do more tests, but that was predominantly the stepping stone of how can I take the rest of the engineering seriously if the whole report, which designates how the stormwater system could be actually done, has some questions on it, in my opinion.
I'm just rereading the judge's initial remand or decision.
While you're searching, I'll just read into the record here one of the stats for the runoff. The applicant's coefficient indicates the runoff volume for the 2-year storm will increase from currently 29,000 cubic feet to approximately 66,000 cubic feet under post-development conditions, more than doubling at a 2.3%. So that is just in general, the amount of extra water being put through that pipe based on this application, which obviously is substantial with no real proof of how it would affect the downstream flooding and if the pipe could actually hold it. And put that on the record. And I think I'm done now.
I'm just reading, because I think one of the things that His Honor has concern is, that we rejected 2 engineering experts and appear to have aligned with the single opposing view, and I'm just reading what His Honor had set out in there. Now, one of the things, our expert, and I'm sure they're, our engineer at the time and the plains engineer, there was, he made a quote related to the peak flow rate, and again, that wasn't necessarily where our concern was more about, again, the overall volume and the release timing of that stormwater and how it would interact with what was going downstream and the contribution from upstream. And that's, I think, again, where I don't know if I would say we had disagreement. I don't think that was ever fully addressed by, the other engineers. I don't think we got into that debate necessarily, and I believe our board engineer, did not fully opine on that. So I think that's where, and hopefully with what we're putting on the record tonight, it's really where the basis of what we had is not necessarily the peak flow rate, but again, the impact of that overall runoff or the addition of stormwater contributing, to the downstream issues, where the neighborhood would be impacted, but again, in relationship to the Raritan River during a major storm event, and again, what's coming down from upstream. So,
And the new development as well.
well, yeah, I mean, that will be a contributing factor, but I don't think at the time there was any maybe data or information available, but it certainly was there, because I think we were hearing that application about the same time too, but and again, that's really, why we made these requests. And again, I think the applicant has to take full responsibility for denying, or not denying our concerns, and and depending on what the results would be, we may not even be here, but we won't know, because for whatever reason, they decided not to do it. And again, I don't think we were unreasonable at that point. We made multiple, and clearly throughout numerous hearings, it was kind of no-brainer where we were heading, I believe, or the majority. I can't speak for everybody that was on the board, whether here or at the time, but I certainly know I was not making my, thoughts or concerns hidden as we went through that. So it was not like we put this requests at the last minute or at the time they were doing closing arguments. So I think, again, I think what we did was reasonable. I think it was actually, within our legal obligations. And again, the plaintiff, for whatever reason, did not want to know those answers or provide those to us. So,
I would agree. I mean, obviously, this was, I don't know how many meetings this was, I think it was a good year plus, and I think we spent probably 70% of it on stormwater, right? Between the testimony of both sides' experts and the fact witnesses, and there was plenty of opportunity for questions and answers, and for reports to be supplemented over time, and tests redone that were requested. So this wasn't done in a vacuum of a couple meetings. This was a very long process of an application that the public, the board, and the applicants it was a very informative dialogue on all parts, the public also, to what they could provide. And we were all just seeking information and assurances, probably the best way to put it, that this project would not be detrimental to the area. And so I believe that, the testimony and the record is very thorough in the ability to do the proofs that were required and in some ways fell short.
Any other last thoughts, comments? So I believe at this, I got a point, yeah. You're all the way over there by yourself. Should have been over on here. Twist my head. So at this point, I should be entertaining a motion to either,
We're going to go kick it back to me? Okay. The issue is, at this point, the board, I assume, is done deliberating above and beyond what it has already stated prior on the record. The issue is whether or not the board believes that it has further supplemented the record and either supports the decision of the board previously with the supplementation, or whether the board wants to go in a different direction as to this application. So,
So the motion would be to affirm the previous decision or deny the application?
the motion would be to affirm the previous decision of the board in denying the application for the items previously placed on the record and supplemented by the record this evening.
are you offering that motion, Mr. Lapani?
So I made the original one. So yes, I would make a motion to affirm the previous decision based on the previous testimony and the supplemental deliberation on today, that this application would be denied as stated previously
And tonight,
and tonight.
I will second that motion.
Okay, so just for clarification purposes, a yes.
yes
Represent- to deny.
is to affirm the previous decision to deny the application for the reasons stated previously as well as this evening, based on the testimony in the record. And I would, if anyone wishes to comment on the motion, they can do so before we take the vote.
Okay, so we have a motion and a second. We've defined what a yes vote would mean. Any members of the board? Any questions? Final comments?
Yeah, my final comment would be the, I guess, additional information in the form of the DEP permit from 2024 was based upon the approved plans by Van Cleef. And I think that was where we had, the issue with the drainage and stormwater runoff issues. So using that information, that's, I think where we had we were at loggerheads with that. So that additional information, I don't think was enough to overturn my original decision. So I will therefore affirm yes to affirm our.
You're not voting yet,
Okay.
but we know where you're going.
I thought we had a motion in a second.
Oh, no, I didn't ask for a roll call, just general comments.
Okay. That was my
No,
general
but
comment.
thank you.
Sorry.
Okay. Anyone else? Okay. Yep. Okay, with that, may I have a roll call, please?
Mr. Wagner?
Yes.
Ms. Smith?
Yes.
Committeeman Lapani?
Yes.
Vice Chair Peason?
Affirm, yes.
And Chair Sirachi?
Yes. Okay, so the motion carries.
I will indicate to the board that we will produce a revised resolution in normal course. This is not necessarily the same time frame that would be established in accordance with the MLUL for providing a resolution, but we will provide it. We will circulate it to the board. We will circulate it to Mr. Bada. And I would assume at some point in January or February of next year, you will adopt. We are going before His Honor next week. I actually may have to ask for papal dispensation to come in by Zoom, because I'll be with Judge Jacobson all morning with a couple of you. And therefore, I have to reach out to the court, but it is set forth the next conference for next Tuesday at 11:30 while Committeeman Lapani and I are going to be spending a glorious morning on affordable housing.
So fun.
But I'm sure worst case scenario, Mr. Bada will spare me, but we'll figure it out.
Well, just a reminder, we do have a meeting next Thursday evening on the 11th, and we do have an applicant. So with that, I'll entertain a motion of adjournment.
So moved.
Second.
All in favor?
Aye.
Aye, we're adjourned.
Good night, all.
Right.